I did the analysis. I looked at the communications. I determined that they were not discoverable.
The DA didn't turn these things over, and when asked to do so, said that they weren't discoverable. Well, they were. That amounts to a willful violation.
For a year, stood on it being dismissed and dropped, and that never mattered. You know what?
It is what it is. The case is dismissed. Let's call up 25 CR 1011, People versus David Ariano.
He indicated to me he believed the statements she had made were not discoverable unless they were exculpatory. He indicated to me he went through the notes and that he determined they were not exculpatory. Obviously, I don't know that Mr. Stone, not knowing our theory of defense, is in the best place to decide what is or isn't exculpatory in this case. Either way, the fact that she said at times certain things that made them not want to proceed on this case potentially certainly seems exculpatory to me. And so those have not been disclosed to us. Ms. Gillespie says, hey, I just want to let you know, like, I got my laptop back. And he was like, okay. She's like, I just sent you another email. Which suggests that she had also sent a prior email. And she indicates in that call, this was just a big misunderstanding, and that she had sent him an email to that effect.
To whom?
To Deputy Mitchell.
Okay.
Those emails have not been disclosed to us. I mean, this is a very short conversation, right? She's asking about getting the charges dropped against Mr. Ariano. She's asking if she can file a motion to quash the warrant on his behalf in this phone call, but she's not talking a lot.
I'm not making an argument one way or the other as to whether I will or will not disclose these emails if they exist and if I get them, but that's my interpretation of the rule.
Listen, I'm going to take a pretty expansive view of what needs to be turned over. I know that we can parse language, but the whole point of this is that if it's even arguably exculpatory, and in all its various iterations that you can do this, if it says something along the lines of this didn't happen the way it happened, or this was all a big mistake, or here's what really happened, something like that, it needs to be turned over. Right now, I doubt these exist. Yesterday, in the afternoon, the court received approximately 115 pages of information and documents from the DA's office that relate to their, I guess, interactions with the victim during the pendency of this case. There are many different kinds of records here, and the court was a bit overwhelmed, but I still went through and did the in-camera review that I'm definitely required to do in this kind of situation. I'm telling the parties that most of this is going to be turned over. That's the emails between Mr. Stone specifically and the alleged victim, and that's actually a very small part of it. There's also communications that occurred between the alleged victim and the DA investigator. Those need to be turned over in this regard. But the most troublesome one from the court's perspective, and the defense has to know this and has to be able to address this if they choose to, is there is a portion in here where there is communications about the alleged victim's warrants that are outstanding. And the fact that, I mean, I don't know the ins and outs of it, but apparently the warrants were quashed. For the record, I'm going like this. What are we supposed to do? I mean, I don't see how that should never be held back from the defense. It's something that may be able to be impeachable information. I'm really nervous about this, and that's why my voice is quivering a little bit. It's just the fact that I don't understand why this wasn't turned over. And there's literally 115 pages here. But the vast majority of it's going to be turned over. And I needed to let everybody know that obviously this is a pretty major issue from the court's perspective. Obviously, I did this last night, the in-camera review. I've done as much research as I can this morning to sort this out and to think about this issue, because the court recognizes the gravity of this. But there is a bunch of stuff in here, and it should have been turned over. I'm sorry.
So, I mean, I can tell the court yesterday afternoon independent of this, I discovered that the DA's office had filed motions to quash Ms. Gillespie's warrants.
It appeared to be, looking at the text, that these were recent. I mean, but there's
Yes, Your
dates
Honor.
on here. I don't
I
know.
believe it was August 6th.
That they filed those motions. Which is, in my opinion, pretty unusual for the district attorney's office to file a motion to quash for a defendant.
It's referenced in here.
And I was unaware until then.
I mean, the court is saying that almost all of this is going to be turned over. I don't understand how this stuff falls under Rule 16 or my obligations. As I represented to the court yesterday, I reviewed all of it, and I don't believe this is exculpatory. Obviously, the court disagrees with me about some of this stuff, and maybe there are particular issues or particular things that are exculpatory or that should be turned over. I fundamentally disagree that the vast majority of this is discoverable.
Certainly recognize where the prosecution is coming from. That's how come I've been struggling with this. But some of this stuff is obviously needs to be turned over, especially the warrant aspect of that. That has to be turned over.
The communications between the emails that the victim sent Mr. Stone relate to whether the charges should be dropped. To me, I understand there are two arguments that can be made for both sides in regard to that, but that's for the jury to sort out if it's admissible, if it's relevant. But at the same time, the defense gets a chance to look at it. All right.
Just briefly, Your Honor,
Go
Ms.
ahead.
Watkins referenced the emails to Deputy Mitchell. Deputy Mitchell was in my office yesterday. I asked him to go through his email and look for those. He did, and he didn't find them. So I don't believe they exist at this point.
All right. We will readdress at 1:00. Okay, and we're all just going to have to do the best we can. This is crazy, but it is the way it is. I've done the best I can to extract from the 115 pages the things that the court is not willing to have turned over to the defense, which is a substantial amount of it, to be quite frank. But there is also a substantial amount of it that the court's going to, at this point in time, require to be turned over.
I understand the court's not going to make the ruling now related to the discovery violation. I mean, I'm unsurprisingly requesting that the court dismiss the case. Additionally, pursuant to Giglio, I believe benefits that another criminal defendant are receiving in exchange for their cooperation in another case are mandatory disclosure as well, which it does appear happened here with the district attorney's office moving to quash warrants on behalf of Ms. Gillespie in order to get her under subpoena. That is pretty direct impeachment evidence and a clear benefit that she received, again, that most defendants don't receive, frankly.
But at the same time, it is clear to at least me that some of this stuff should have been turned over. But I know that Mr. Stone vehemently disagrees with that, and I respect that. So let's hear what he has to say.
There will be one caveat to this, but nothing that Ms. Gillespie sent to us, I'm aware that I'm not aware of anything in there, and I reviewed all of it, that tends to negate the guilt of Mr. Arellano as to the offense charged in this case. The caveat is, and I will concede, that we should have disclosed to the defense that we moved to quash Ms. Gillespie's warrants. The reason we did that is because she would not meet with our investigator for us to serve a subpoena on her.
And let me stop for just a second, just so that I can add to the record on that, because that's part of what's, I'm sure it will still, at least in that respect, be turned over. I mean, it was indicated, one of her responses was, I'm not going to talk to anybody until the warrants are quashed.
Right.
I don't know if that's a direct quote, but it's pretty close. So that is well taken. Go ahead.
And so and Your Honor, I'm still learning. It frustrates me to no end to have to be here and make that concession. That should have gone out. Absolutely. We should have disclosed that to the defense. I think that is impeachment material, certainly.
They are directly from the alleged victim in this case to Mr. Stone himself. They have information in here that indicates what the alleged victim wants done with the case. and also in many instances, wanting the charges to be dropped. For example, to quote in the March 10th one, I'll just read it because it's real short. David has come a really long way. I am pregnant with this kid, and me and this baby need him. I really would prefer the charges be dropped. Above that, there was the Michelle Holney's email, and then there was a response to the email, and Ms. Gillespie simply says, "I don't want to be a part of this case anymore." So it makes things very difficult from the court's perspective, but it relates to this case. As a human being, I'm putting aside right now, obviously, me being a judge that needs to look at these things objectively. But I'll be frank, reading those texts was abhorrent, absolutely abhorrent, and I'm not at all minimizing that. But it's a statement of the defendant. It concerns this case. The court is going to order the emails that I indicated between between the alleged victim and Mr. Stone to be turned over. I'm going to order that the texts between the investigator and the victim's witness person regarding the subpoenaing of the alleged victim and also this quashing the warrants be turned over. And whenever I say 115 pages, I was trying to count this at 8 o'clock at night last night. I might be wrong. It could be 112. It could be 117, but I said approximately 115 pages. So please don't hold me to that record.
I am moving for a stay of the proceedings so that we can decide whether we're going to bring a Rule 21 appeal. I am asking for a protective order that defense counsel not disclose that to their client until we have some form of finality regarding how this is going to proceed.
So as far as the protective order goes, I mean, I believe this entire thing was live streamed. So it's public at this point. I can't say that Mr. Ariano isn't watching court right now. I genuinely don't know. I also don't really know how I can prepare him for the possibility of not going to trial next week without explaining to him why, which includes the court's determinations.
This is what the court's going to do. I am going to stay the turning over of these items that I've indicated till noon on Monday. That's what I'm going to do, and that gives the DA the weekend to decide what they're going to do. If we decide we are going forward, then at 12:01, I'm going to direct that these things be turned over to the defense. I think that's the best way to handle it, and whatever happens with the trial is going to happen. In the courtroom, I am going to direct defense counsel to not yet disclose, except for what the court has ruled, the details of the things that I put into the record about the court's findings relating to the specific pieces of information and emails and text and all those kind of things. So for now, counsel, I am going to order that you cannot disclose those specifics to your client. I know that he may be listening in, and that's the way it is.
He has not seen or heard the contents of any of the discovery.
And the court will be frank here, due to the nature of them, I didn't read them word for word.
That's understandable. I can read the part word for word that I am referring to, if that would help.
I think it would for the record.
The one sentence of the text message says, "You're a snitch, two-faced, cop-calling fake victim bitch that talks about how much she hates cops and snitches. When it benefits her, she's on their nuts." That sentence, although vulgar, does directly relate to this case. It is calling the accusations false victim. This was all a big misunderstanding. I don't want to waste anyone's time. I don't want to go forward with this. All a big misunderstanding. It's all a big misunderstanding until there are benefits provided by the DA's office to Ms. Gillespie. That is exculpatory evidence that negates Mr. Ariano's guilt because the sole complaining witness against him has a motive to assist the prosecution. IT performed the search and located 0 emails received by Deputy Mitchell from Gillespie. Therefore, no emails were sent by Gillespie to Deputy Mitchell. So at the very least, no conclusion can be drawn as to whether or not these emails existed because I have Deputy Mitchell on his body worn camera saying, I got your email. Yeah, so she has multiple email addresses. I see right here, she has another email address, jazzitup93. They didn't search for jazzitup93. They searched for the Mama G email address. So there's no way to actually say these emails don't exist because they didn't search for all of the email addresses that Ms. Gillespie could have used. And quite frankly, it is really scary that criminal defendants are going into trial, getting convicted of felonies when we don't even know if they have all of their discovery because we have to dig so hard for it. No, and it's not our obligation to discover it. And that's the trouble. And both sides have to do their due diligence in order for this to work. And when the defense is the only side ensuring that there is adequate discovery and that all of the discovery is disclosed, the system doesn't work and people get convicted of crimes that they're not guilty of. And that's why this is a big problem. The justice system works when the people disclose everything that they need to disclose to the defense, and the defense then decides how they want to defend themselves or what defense they want to put on. But this is not, these are people's lives. This isn't a game where the prosecution can say, I think I can get out of disclosing this, so I'm going to try as long as I can to not disclose it. If the court doesn't feel comfortable dismissing a count, then I'm asking that the court dismiss the habitual felony element of this. So it is a count, but not a new law substantive count. I'm asking that the court dismiss the habitual felony count. That way, at least Mr. Arellano will not be walking into a felony trial.
I did the analysis. I looked at the communications. I determined that they were not discoverable. And then I said, Your Honor, I'm asking for an in-camera review. I continue to disagree that anything other than the information about us moving to quash Ms. Gillespie's.
From this court's perspective, we have different things here. We have what you've already conceded, the impeachment information with regard to the quashing of the warrants. There's also the emails that were directly to you from the victim. And then we have the texts, and then we have the photographs.
And I understand the defense is saying, well, it's a victim, the complaining victim saying she doesn't want to prosecute the case anymore. But that's the people's job, is to prosecute the case. And ultimately, our job is to get the victim here and put on evidence.
That doesn't mean, like the prosecution is arguing, that the prosecution gets to decide if it's exculpatory or not. The prosecution doesn't get to argue or say that something is not exculpatory. That is not how things are determined to be exculpatory or inculpatory. It's a question for the jury and potentially a question for the court. But it is not something that the prosecution gets to decide, because if the prosecution got to decide what's exculpatory, then I fear the defense wouldn't get anything.
I want to preface again by saying that I am not making any finding that the DA did this for any nefarious means. I'm going to make a finding that he willfully didn't disclose the warrant quashing aspect of this, but he willfully disclosed it didn't disclose it because he felt and strongly believed that it wasn't discoverable. But that doesn't take away from the fact that it's willful. To me, it's clear with regard to the warrant quashing texts that the court turned over, that those are definitely relate to the impeachment of the alleged victim in this case, and should have been turned over immediately in this regard. To me, that's the completely obvious one here, and the DA didn't turn these things over, and when asked to do so, said that they weren't discoverable. Well, they were, and that's the bottom line there. To me, it looks like a victim impact statement, and those get turned over all the time. I don't understand, frankly, why the DA wouldn't just turn that over just by itself. It goes through a lot of the victim's thought processes that relate to this case, and it should have been turned over. So the court finds that there are discovery violations on all four of the things that I've talked about here. And now the court would turn to what the proper sanction is in this matter. Well, there's nothing nefarious here, and there's nothing dishonest here from on the part of the DA's part, and I'm sure certainly not taking that into account, that anything like that, because I don't believe it. But at the same time, as I indicated, it was still willful. The DA was asked to turn these things over, and he said these are not discoverable, and this court has ruled that they are. a question whether this court can properly make the DA turn over those texts and those photographs. And so whenever we're in a situation like that where it's arguable, and which this court recognizes, I don't find that to be a knowing or willful violation of Rule 16. But not turning over the statements from the alleged victim to the defendant, to the DA, and also certainly the not turning over of the text regarding the quashing of the warrant. I keep on losing the word quashing. Are certainly willfully done here, and anybody who's looking at this would have known that this should have been turned over, and there's just from this court's perspective no doubt about it. The whole point is to advance the search for the truth, and when these things are not turned over to the defense, it retards that possibility. And that kind of leans now to what the proper sanction is in this particular case. I'm not going to dismiss the case. That would be too far from this court's perspective. But a continuance, it doesn't feed the bulldog either. Also, making it so that the alleged victim cannot testify is tantamount to a dismissal. I'm not going to consider that. From the court's perspective, what's appropriate here is to dismiss a charge. I think what the proper sanction here and what the court is going to order is I'm going to dismiss count number 3, which is the felony habitual DV charge in this matter. That still allows this case to go forward, but there still is a sanction for the DA willfully not turning these things over and the period of time that they were supposed to do so very quickly, and they did not do so. And that's what we're going to do here, but it's not for any kind of pattern. It is simply because this DA should have turned over immediately this information and did not do so.
Your Honor, just for the record, the people are objecting to the court sanction, but I won't make any further argument about that.
No, that's fair. That's what you needed to do. Thank you very much. So that means we're down to 24 jurors. So obviously it's fortuitous. I'm not going to say fortunate because that would be wrong. It's fortuitous that the felony was dismissed because there's no way we could have gotten a jury. So at least we have a fighting chance with this.
The first of which is that Miss Gillespie is now in the courtroom.
Hello.
Our investigators picked her up on her subpoena, and she's here. I understand that she's in quite a bit of pain at this point, and so where we're going to be doing jury selection stuff, my inclination is to let her go back home, but I wanted to bring her to the courtroom, and I'm asking the court to admonish her that she is under subpoena.
And what that means is that if you don't show back up on the subpoena, it's possible, and I'm not saying I'm going to do it because I don't know, but it's possible that you could be held in contempt of court if you don't appear on the subpoena, and that could be up to 6 months in jail. I'm not threatening at all. I'm just telling you the reality. And that's just the way it is. That's what the DA wants me to do.
Thank you, Your Honor. The next issue is that I am moving the court to reconsider its finding that there were willful discovery violations in this case and its sanction of dismissing the felony count. And I have some record to make on that.
Counsel, why don't you go ahead and do it in writing? I've dealt with this issue. We spent 2 days on it. I'm willing, obviously, for you to make something in writing, but I want to get this trial started if we're going to do it.
Okay.
All right. I'm going to, at this point in time, I'm just not going to consider it.
No. So just for purposes of the record, Ms. Gillespie is saying that she didn't know that we quashed her warrant. She thought her public defender did. I emailed the defense that, in my opinion, it wasn't exculpatory. I was clearly wrong about that. As far as the willfulness, I've thought about it a lot, and I don't believe that there was any willful or knowing failure to comply with my discovery obligations here. And so with that, I don't think that a dismissal of a count, certainly a felony count, that's generally a sanction that's reserved for when there are willful violations. And so that's my motion. I'm asking the court to reconsider.
And I think the practice is, the expectation is that the people know what Rule 16 and Brady covers. And so when they're asked for these things and they decline to turn them over, whether or not it's I'm a brand new attorney and I don't know fully the rules or I don't fully understand them versus I'm a 20-year veteran attorney, I think the practicality is the same to my client, which is a violation of his due process rights.
I'm not going to reconsider my order. I was expecting, 4 pages, 2 pages, or something like that of stuff that probably didn't have any relation to the case. I was expecting something like maybe services rendered, victims compensation type stuff, and I thought it was going to be a 5-minute deal. But that afternoon, my clerk brought in that 115 pages of stuff, and it was clear to me upon going through it that this was not vetted. This was not looked into. There comes a point in time where, I find Mr. Stone to be a credible, honest individual. And I know that sometimes there's obviously fighting across the board with regard to whether stuff is done on purpose or for nefarious means. But I find him to be that. So I don't disbelieve that. But at the same time, he was asked to discover this material, and he said it was not discoverable. That amounts to a willful violation. So the court will not vacate and reconsider its order at this point in time regarding discovery. I think we probably need to have Ms. Gillespie go ahead and go home if she wants to go home. Yes, ma'am.
Is there any way that I could just testify now?
No, ma'am. We have to go through the whole jury picking process. And
can I say something? I literally for almost a year wanted this case dismissed. I had right away when he got arrested motioned for it to be dismissed. And it's been over a year now that it's been going on, I'm 30 weeks pregnant. I'm there's a lot going on at this point. I haven't been involved in much. The one court case that I did see, all I saw was him saying that the only reason they decided to continue this was because of me. And if that's the case, then it should just be dropped honestly or dismissed, because I, for a year, stood on it being dismissed and dropped, and that never mattered, and then
I'm a female and Peggy and hormonal, so we get in a fight.
Hold on. We are getting all of this on the record. Is that correct? Okay. Keep going, ma'am.
So and then we get in a fight, and I email them back once, and then all of a sudden it's because of me that they're pursuing this whole time when I wanted it dropped, and it would have made easier,
I hear you, ma'am. And let me stop you. It's not that I'm being rude. You have to understand that the court, the judicial branch, does not bring the charges. I have no bearing
on what charges are brought and what charges are tried. That is a DA function. And I'm not going to get in them. I cannot, first of all, tell him what cases he can try and what charges he should go forward on. I cannot, period. So we're going through this, but I've seen your facial features and also you nodding your head up and down. It's pretty clear to me that you don't want this case to go forward, but that's not my call. Simply not my call.
The defense is ready, Your Honor.
Okay.
Thank you.
Go ahead and call the jury down when you're ready.
Your Honor, I apologize before we call the jury. I just got new information from Investigator Talindi that I need to discuss with her.
Have we called them down?
If we could hold on.
Yes, we have.
Why don't you stop them? Well, they would need to come into the room anyway. So
Yes.
Let's go ahead and do that. They can wait out in the hall.
Okay.
Go ahead.
I need to discuss with Investigator Talindi something that just came up. And so it was a new statement from Ms. Gillespie that may be dispositive of the case.
Okay. All right. Let's discuss that, and then let's see what we're going to do.
Well, I just got a message from Investigator Talindi that Ms. Gillespie stated that she did take Mr. Ariano's phone because he took her daughter's present. So it was a back and forth tit for tat thing. And so I want to vet that, but that's the information that I have. And I think the court can guess where this will be going if I I need to dig into that a little bit more, but I expect that I'll be just moving to dismiss the case. The jury was outside in the hallway. I walked past them twice, didn't say anything to any of the jurors, and didn't have anything said to me. As I stated, Investigator Talindi, with that new information, which directly contradicts what she told law enforcement, I can no longer prove this case beyond a reasonable doubt. But at this point, with the case the way it is, the charges the way they are, I am moving to dismiss the case.
It is what it is. The case is dismissed, and the defendant is free to go at this point in time. I am going to say that what I usually say for these kind of cases, this case was snake bit. Oftentimes they use it in the context of a horse getting bit by a snake, and so it makes the horse lame. And so you cannot go forward.
The District Court Division 12 in and for the 21st Judicial District in Mesa County, Colorado is now in session. The Honorable Craig P. Henderson presiding.
As Ms. White said, my name is Craig Henderson, and I would have been the judge that presides over this case. And you can tell by the way I said that we're not going to have trials. But I know that we've held you all morning long. We've also made you come down the stairs and wait in the hallway for a long period of time. I think you have a right to know what happened here. I can't tell you everything about what happened here, but I can explain what was going on during that whole time that you were waiting patiently. There were a lot of legal issues in this case.
And the legal issues were such that they were very difficult to sort out, and they were very difficult to rule upon. And then also, sometimes things come up at the very last minute that nobody knew about. And that happened here too. I like to call I'm kind of a Western individual, and what I do is I call these kind of cases snake bit, meaning that it's just not going to work. It's not going to happen. And the DA appropriately dismissed this case. And that means we're not going to have a jury trial. And I just wanted to explain to you what was going on here, that we weren't just in here messing around. I have legal issues that I have to decide before we could even get to you. And that causes you to have to wait. And I apologize for that. And I appreciate it when people actually show up for jury service, because that doesn't happen all the time. And I think you have a right to know what happened. This case was dismissed, and you don't have to be a juror on this case. And your jury service is done for a year, and you are free to go.